we hear so many instances of things like digital arrest, and Indians are not really conscious of how dangerous it is to not be mindful of their data.
Awareness is always going to be critical because this is a consent-based legislation. So which means that if it is established or proved that you have provided consent for your data to be used in a particular way, then there's very little that you can do about it. I lived in the United States about 15-20 years ago, and I found it very interesting that they actually had a shredder in their home. And in India, we have of course been in some ways more than ready to share this kind of information. I own the data which is about me, and nobody else, a third party, cannot use that data in some way without my specific consent or without my say-so.
Digital Personal Data Protection Act is a landmark legislation in the history of Indian digital governance. It's likely to be India's first comprehensive data protection law that has repercussions across not just the digital sphere, but pretty much any sphere, given the extent to which personal data, digital information, and radical digitalization has swept the country. To discuss the Digital Personal Data Protection Act, its implications, and what the ordinary person stands to benefit from this new law, I'm very pleased to be talking to Mr. S.Krishnan, the Secretary of the Ministry of Information and Technology. And I hope that in the course of this conversation, we can go through a lot of the motivations behind the law, understand what is unique about the law, how it fits into the overall future of India's digitalization, and how it will change the lives of citizens, enterprises, and everyone else who deals with the country. So first of all, thank you very much for doing this. I thought perhaps we'd start with locating the law in the context. Why is it that we need a digital data protection law at this time in India's journey?
I think there's been this awareness and concern about protecting data and protecting personal data. Some of it was part of the IT Act itself, and there were some provisions which specifically dealt with it. But once the Supreme Court passed its orders on the Puttaswamy judgment and talked about privacy being part of the fundamental rights, there was a feeling that we needed to legislate specifically on this. And the Puttaswamy judgment was sometime in 2017. It took a number of iterations before the present version of the Act came out in 2023. And I think in a number of ways, this particular act, and as you yourself pointed out, there's so much of digital data which is sloshing around, so much of information about individuals which is all over the place, and there is no regulatory framework or there's no framework on how this data gets in there, how it gets out, who uses it in what form. None of those are governed by any set of law or rules. And people often find themselves, their privacy violated, things which they never intended to be in the public domain, getting into the public domain. A lot of those issues frequently come up, and which requires that government had to necessarily intervene and legislatively intervene. And that is what happened through the Digital Personal Data Protection Act.
So I want to spend a little more time on that. I mean, we hear so many instances of things like digital arrest, and there are so many harms that are being perpetrated to people because their information is perhaps accidentally shared with someone. Could you perhaps spend a little time on talking about, I worry that Indians are not really conscious of how dangerous it is to not be mindful of their data. Of course, the Act is going to help, but we also need to understand the consequences of the data.
No, you're absolutely right. The Act on its own doesn't solve the whole problem. Because while the Act, and I'll come to that in due course, does create a framework, but it is really how each one of us individually exercises our rights and exercises the powers that we have under the Act which become important, and the way that we hold people who keep our data, how we hold them to account also becomes important. So which then means that awareness is always going to be critical because this is a consent-based legislation. So which means that if it is established or proved that you have provided consent for your data to be used in a particular way, then there's very little that you can do about it. Therefore, providing informed consent is very important, and individuals need to realize the implications of the consent they are giving and the circumstances in which the consent is given. And you were talking about this example of digital arrest and issues of that kind. Really, where do people get that data from? They get it from places where the data has been previously shared. Somebody has picked it up based on some hotel registry where Aadhaar numbers have been recorded, addresses have been recorded. Somebody has picked it up from a courier man's list of where parcels have been actually delivered. I find it very interesting that, I lived in the United States about 15, 20 years ago for a fairly long period. And we used to have some friends whom we used to visit. And I found it very interesting that they actually had a shredder in their home. Okay, and I asked them, saying, "Why do you have a shredder? I mean, this is typically something we keep in offices. If there are confidential papers and so on, we shred them." He says, "No, we shred all the junk mail we get, because if you throw the junk mail out as it is, then my address is there, various other things are there. Somebody goes through my trash and collects. I could be the victim of identity theft." That is the level of precaution that they were taking, that, shred everything and then throw out the junk so that personal information, including name, address, and something else which may be contained in any junk mail, doesn't go out. So this is the extent to which in certain jurisdictions people are conscious of personal information and the possible risks of personal information getting out. And in India, we have, of course, been in some ways more than ready to share this kind of information. Anybody who asks us, we are happy to give information way beyond what we need to. For instance, you go to many stores and so on, even before, as you're paying, even before the cash counter opens, they ask you, "Give me your mobile phone." And you really don't have to, but many people do. And you get the impression watching people in line ahead of you that the cash counter would actually open only if you gave them the mobile number. So people do. There are multiple, behavioral tricks that are played, nudges which are given to actually part with data, and the risks of this are quite immense. I mean, let me again illustrate, and again from personal example. When I just went to the United States, this was sometime in 2007, I didn't have an address of my own, but the employer needed that, I should get a social security number. So it got mailed to one of my colleagues' house, which was in another state. And so even now, I mean, almost 18 years later, if you look at my Gmail account, you would still find either in the junk or in the spam or in some other folder emails which come saying that, you live in this particular area. These are all the people who have criminal records in that area, or these are also protect your reputation, protect this. So this is the extent to which people can actually pick up some piece of data about you and use it. So this is awareness which is very important. And what we see now in India is a rash of, using this kind of data to push something else. I mean, something as simple as, how does the digital arrest thing start? It starts with, oh, there is this package which has arrived for you which has contraband. I mean, which is typically one of the things that starts. And then there is some, official looking person, either in a police uniform or in a customs uniform, who kind of tells you can't move around till you do this and till you do that, to the extent that they've even faked, courtrooms and, pretended to be judges of the High Court and Supreme Court, no less, saying that we are passing orders. Part of it is the convenience element, saying that, we are using digital means, courts are using, video conferencing facilities as a means of ensuring appearance. So, and at one level, there is awareness building about that, because that's a good thing. And, for bail hearings, they are saying that you don't appear in person and we'll do it on video conference. But under the law, there's no way that you can arrest somebody digitally. And that is one thing which has to be done physically. So, which means that awareness is critical and important. This is something even the Prime Minister spoke about in one of his Mann Ki Baat episodes. Clearly, this is something which all of us have to be very aware of. So we have to be aware at two stages: where we share the data and in what form we share the data, because you don't have to necessarily give it in every case. You have to be circumspect about how much data you share with anybody when you're asked. And the second point is be fully aware that when somebody is contacting you through digital means, whether it's an email, whether it's a SMS message or anything else, it's truly for a legitimate purpose. I think both elements, there's a lot of awareness which is needed. And what happens typically is, of course, there are the youth who do a number of transactions or who are parts of various kinds of games and so on. But for the older people, sometimes also it's a matter of great anxiety, and also they tend to, they probably, retirees and others tend to have some money or some wealth, and it's sometimes easier to tell them that this is how it works and why don't you. So that kind of awareness and protection against crime is a different aspect. But it all begins with having shared the data at some location or in some form, and that data being used for illegitimate purposes. And that's partly what the Act tries to fix.
And I think your insight of 18 years ago this happened in the US, in a sense, India has lagged behind that. Because 18 years ago, we were not having this kind of consequence of putting our trash in, our address in the trash. But it's caught up with us because India is radically digitized. And so, in a sense, we are seeing an explosion of these sorts of things that we were perhaps protected for all of this while. So, as you said, I think let's leave digital arrest because that's a consequence, and let's just go to the source of it. If we could just go into now the mechanics of the law. How has the law been designed, and how is it supposed to work? And I think obviously we're not here to do a lecture to people on everything in the law, but there is some nomenclature in the beginning of the Act that is important to understand. We've got terms that perhaps in our conversation also we'll use, and perhaps you should get it out of the way that everyone understand what it is. So we have this concept of a data principal, a data fiduciary, and a data processor. And I think perhaps if we can just understand what exactly, and these are also unusual terms because in most other laws around the world, we call it data subject, data controller, but we have chosen this idea of data principal, data fiduciary, and data processor. If you can explain what they are, who would be some examples that would really help?
I think fundamentally what the Indian law attempts to do, the DPDP Act attempts to do, is to actually empower the person to whom or about whom the data itself is. It recognizes the person as a data principal. He owns the data or she owns the data about herself. And this I think is a very empowering concept that I own the data which is about me, and nobody else, a third party, cannot use that data in some way without my specific consent or without my say-so, which is why we call it also a consent-based law. Almost everything under the law has to happen with consent. So that is one. Data principal is the person about whom the data is, and that personally identifiable data is clearly recognized to be that individual's data over which he has control and over which he has agency. So that is, I think, a critical point, and it's a very important construct that we need to understand. And whoever she entrusts the data to is then the data fiduciary, because then they have a fiduciary responsibility of holding that data in trust and not to do something with that data beyond what has been consented to, beyond what the data principal has said you can use the data for, or beyond those legitimate purposes, you don't use the data. And you also undertake to safeguard the data so that even accidentally it is not lost, or due to carelessness it doesn't go somewhere else. I think that again is a very important principle, that the person to whom the data has been given is responsible to make sure that they really take care of the data in the way that it's intended to. So instances which often happen of, just selling a list of addresses, names and addresses, or selling a list of these will not happen. I mean, it's very interesting, and these are things which need to be addressed. About a year or so ago, we have a little trust, and we registered the trust. And then when we had to open a bank account for the trust, we had to go to the NGO Darpan portal and open it, which is run by MeitY, NIC, on behalf of NITI Aayog. Now, yes, there is access to that because that's a visible thing. So the NGO Darpan portal, we registered this NGO. The minute we did it, what happened is, of course, some of it is data in the public domain, and we have to recognize that if you are registering a public trust or a public organization, it needs to be. But it's commercially valuable to somebody. Good. So I had banks emailing me saying, we find that you opened this. Would you like to open your bank account with us? Would you like to do this with us? Somebody else emailing me from Karol Bagh saying you want other clearances like FCRA or something else, we'll help you. So you realize that this is how data can be commercially valuable or commercially important for somebody who's either soliciting very legitimate business or trying to work this. So which then means that anybody who collects this data can also sell it, without your expecting it or without your realizing it. Which is why it's then very important that the data fiduciary is made to realize what his responsibilities are and how they are expected to hold the data and the manner in which they can actually use it thereafter for whatever purposes. So that is why the concept of the data fiduciary is very important. And then, of course, in a digital system, a lot of this data needs to be sort of processed. And the person, I mean, if you're a bank or if you're any other institution, you may not do all of this yourself. I mean, the entire India's IT economy is structured on the basis of outsourced management of many of these data functions. So that data will go to some third-party entity who processes it. And that is the data processor. So the way the Act itself has been designed is the primary relationship is between the data principal and the data fiduciary. And then there is a secondary relationship, which is primarily contractual and governed by contract law, between the data fiduciary and the data processor. So the data fiduciary then becomes a very important person who's held accountable for all of his actions.
Yeah. No, I mean, I do want to underscore this because whenever I have taken this construct abroad, and of course, data protection has been around since the 1970s, actually. It's amazing how Europe comes back and said, look, we wish we thought about that. Because we flipped the narrative to say that this is not a law about the data controller or the data fiduciary. This is actually a law about the data principal, because we are empowering the data principal. And the articulation of the fiduciary relationship once again flips. You are holding it in trust. It is your responsibility to take care of it, which is a flip in the relationship. Now, I think from there we can go to what you've already mentioned many times, which is the consent-based nature of the framework. What's the mechanics of the collection of data and the processing of data under the Act? I think intuitively we know that I need to exert agency over what you do about my data, but how do we implement the mechanics of it?
I think fundamentally the issue is that data has to be, under most circumstances, voluntarily given for a set of services. When I approach somebody saying that these are the services I require of you, whether it is a bank to open a bank account or some other entity, then I share the data voluntarily. But then the person who's taking the data from me needs to specify what he's going to use the data for, the purpose for which the data is going to be used. And the second part of it is that he's also going to limit the total amount of data that he's going to take from me just for the purposes for which he's intending to use it. So unnecessary detail and too much of other data will not go in. And that's the principle of data minimization, and we'll come back to that later. So the element of consent then becomes very, very important. I mean, as an individual, I can then say, why are you asking for the data? You're telling me you need it for the following purposes. How is this piece of data relevant to that? Why are you asking me for additional pieces of information? I think that is something which, that is a way in which the agency can really be exercised. And tomorrow, I can also hold the data fiduciary to account to say that I gave you the data for the following purposes. Now, you've given it to a third party without my consent or without informing me that it's likely to go to a third party. I think that, again, is a very crucial or critical element that both the data fiduciary needs to learn. You may have been treating all this information casually in the past. You may have been sharing it even informally or otherwise, or just putting it together and giving it away to people. It happens, for instance, if you have a club membership, for instance, then you find that your club has shared your data. So which is why, even though you're not in that bracket which will consume all those luxury goods that, jewelry or real estate or whatever, but suddenly you find yourself flooded with mailers from
targeted
mailers from those kind of agencies. Now that you can't do in the future.
So to get back to your example of when you opened the NGO, you had opened it for the purposes of getting that registration. And if someone, and I'm not saying someone has, maybe as you said, it's a public portal, so they went and got it. But let's say you got a club membership and they, instead of using your address just to deliver your club bill or to send you some mailers, they also gave it to someone else. You can now say that you have not used it for the purpose for which I gave it.
Or you have to now explicitly say, do you consent for this to be shared for this purpose? Because I may be interested. I may be looking for buying something and I may want some of these mailers to come in which case I explicitly say
consent
yes.
To it, yes.
If I don't consent to it, then it shouldn't be shared. Yeah.
And are there, I know that in the Act, we also, you mentioned that largely consent. There are some other uses where data can be used. So right. There are provisions, one for exemptions from some of the provisions of the law, as well as for other legitimate uses.
Legitimate purposes are, in certain cases, if government is intending to target certain subsidies or target a particular scheme to a set of possible beneficiaries, what is called proactive governance. If I want to say that, previously you've been eligible for a particular scheme and you've taken benefit under that scheme, you may now be eligible for something more. For instance, just to give an example, now suppose a child is born and under the scheme in which there is a payment for childbirth, up to 2 children, government gives money, then the next stage, when you realize that the child would be 3 or 4 years old, or you have to immunize the child, so you say that this immunization service is due, will you come and get your child immunized? Later, school admission is due, will you come and get the child admitted in school? Likewise, for some family which is, say, or later on scholarships. So those kind of purposes where there could be actually a benefit to the family and there's a public purpose, larger public purpose being served, those are some legitimate purposes. Likewise, emergency medical care is something where it is needed. Then in the case of employees, sometimes you have to look into the database to figure out, verification of antecedents or some other
Or
sort
quite
of
frankly,
benefit.
if an employee is misappropriated funds or done something illegal, you can't be asking them consent to do an investigation. So, I think that it would also be a reasonable use.
So those legitimate uses are something which the Act itself permits. And then, of course, for security and other reasons, there are some agencies which are exempt from the ambit of the Act itself.
And then just to now dig a little deeper. So I think we've said that the basis is consent. There are some other principles that you also mentioned in passing, but I think we should get into it in a little more detail. This comes from this whole concept you said earlier on, which is we should not over-collect information. We should only collect as much information as is required. And those principles, three of which you mentioned, are purpose specification, data minimization, and retention restrictions. Essentially, what is the purpose for which you're using it? What is the minimum amount of data that you need to collect for that purpose? And what is the minimum amount of time that you need to keep it for? Can you spend a little more time on this? Because I think, as you've already mentioned, we are not used to this in the country. And data fiduciaries who have been behaving in a particular way up to now need to fundamentally change the way they think and act because of these principles. And perhaps if you can just explain that, it'll be useful to the businesses that are listening.
I think that's very important because, the purpose for which you're collecting the information is something which the data principal needs to be informed of. Because if she wants to give the information and is aware that these are the additional add-ons, well and good. Yeah. If she doesn't want to be bothered by it later, then you shouldn't. Yeah. For instance, I was giving you this example of when you're paying a bill, they ask you for your mobile number. Now, they never tell you why. Right? Yes. It is basically intended to sell you offers later, or in certain cases, it could even be that, okay, we identify you based on this. So if you come back the next time,
loyalty
points or a rebate or a discount or something. Now, I may be interested in that. If I'm interested in that, I will say, yes, please put my number in. But if I say no, then, okay, it's a one-off transaction and I want to get out of this, so I don't want to see any more of this. That is something which I think is important. Now, they have to realize that explicit consent is important and that process needs to be brought in. And the individual sharing the data principal also needs to be aware that when they're asking you for additional data, there's actually a purpose.
Other purposes.
And, we tend also sometimes to imagine that somebody in authority or seeming position of authority, or there's some unevenness in the power equation, you just assume that you have to do whatever the other person asks, or you have to just comply. And I don't think that's necessary. That is what I think is truly empowering, saying the data belongs to you, and unless it is really needed for a purpose, it should not be asked. And a lot of it is taken way beyond what is really needed. Additional fields are collected, additional information is collected, which may not be necessary at all. So that's as far as the purpose specification is important, because and also what you'd use it for afterwards. If you're going to use it, if like in the club example, if you intend to sell that as a data set to various other retailers who are sort of looking for targeted advertising of some of their products,
you must say it up front.
You must say it up front, saying if you are willing to share this. I mean, for instance, you subscribe for, say, some of these online subscriptions, magazines, or then they ask you, saying, do you want to be sent the following mailers? Or do you want us to share this data with our affiliated organizations who may send you mailers? Only if you tick that, then you get it. If you don't tick it, I mean, they do it probably also as some sort of enlightened self-interest, because they realize that their customers who are paying quite a bit don't want to be irritated or bugged by a lot of this, and it may go against them. But I think that is an essential principle which is important, saying if I'm interested, I will ask for it. If I'm not interested, I will not. And I should have that option of saying no, and I should be told the purpose for which it's being taken.
So just to get to the point of the cashier who asked for your mobile number, now, usually they just ask for the mobile number. They don't say what the purpose is.
Exactly.
If they say one step further to say the purpose is loyalty points, but then they use it to sell you some other product, that would not be acceptable.
That would not be. So then you'll have to say it, list out and say all of these reasons. I may also give it to my affiliated organization. I may also give it to somebody else. Or I may also send you offers tomorrow of or information about a product I'm buying, that there's a discount on a line of shoes or clothes that you bought last time.
So that's purpose specification. Then the second is data minimization, which also you briefly mentioned. We perhaps are giving more information than we should.
Absolutely. More information than is necessary in various situations. And I think it's very important that what data gets collected from an individual is minimized to what is needed for that set of circumstances. I think that's been fairly well done in the case of the Aadhaar legislation.
Absolutely, yeah.
What is critically needed is what is collected, and the number of fields are very limited.
4 fields, 2 optional fields,
that's it.
basic minimum.
Basic minimum. And there should be no reason why we want to, or more data should be collected than beyond what is needed. So I think that is a important principle. And in every situation, based on the kind of interaction you're going to have with that particular data fiduciary, only that much data. Now, if you go to a bank, and with the bank, all that you're wanting to do is open a savings bank account, then the kind of data they need from you is limited. Where your address and your identity and, the way the money comes in. And you continue banking, they don't need anything beyond that. On the other hand, I go back and say either give me an overdraft or give me a facility for a loan or a personal loan, then more information would be needed, and that would be purpose specific. I go and say, look, my son has an education loan, so support that, then there could be more information. So I think each one needs to be based on the purpose and minimize for meeting that particular requirement. I think that mindset is also important. And I think that also leads to greater efficiency, even in businesses. You won't unnecessarily collect data.
Yeah, I think businesses are of the view right now we'll collect as much data as we can. And I think that is a fundamental shift that we have to do. So. And I think the last one is retention. And I find India is actually quite remarkable in its law in that we are actually saying that after a particular point in time, you have to delete the data if it has not been touched. I know this is going to come out in details in the rules, but there is a provision which says, around the world, they say you must only retain the data for as long as is required. But we go one step further and say that, look, at some point in time, you will have to delete the data or make it inaccessible. Once again saying, I see it in three axes. First is purpose. So you must only collect for the purpose. Within the purpose, you must only collect as much as is needed for the purpose. There could be many more you could collect, but only the minimum needed. And then retention is even what you've collected, you can't keep forever. You have to keep for a period of time. So this is a very powerful shift in the way in which we need to be thinking about data.
This is what people often say is the right to be forgotten. And as an individual, if my data is not getting used beyond a particular point, then it should get deleted. And especially when it's used for various commercial purposes and so on, I think, and if I've not ordered, I'm on this delivery app and I have not ordered for, say, a period of 1 year or 2 years or whatever is that period we may specify, then it should just it should drop off from that database. Why should it continue to be retained there? It was probably a one-off transaction. You kept it for some more time for convenience and so on, to identify who's the person and where to track them. But if I've not ordered again, or for some reason I've not found it useful, it should drop off the database at the end of that period. So that is, I think, the principle of retention, saying don't retain it beyond the period that you actually need it. And there's a legitimate requirement as to why you need to keep the data.
So this is all the obligations on the data fiduciary. But this is of no use if the data principal does not have rights. So it's detailed in some amount of detail in the law. So if you could just take us through what rights I as a data principal have. You've mentioned some of them already, the right to query. You have used my data for the purpose. Can you show whether it's the purpose? Yeah. Can you go through some of the rights that are available?
Yeah, I think there are about 5 or 6 rights which the data principal has. Like you said, you can ask saying, what have you done with my data? Where is it stored? Is it safe? You can ask saying, right to ask for a deletion, saying that you've used it for long enough, now get rid of it.
So the consequence of the data retention obligation is the right to delete after the retention is over.
After the requirement is over. So all of these rights are specified in the Act and explicitly provided to the data principals, saying that they can actually exercise them, and which is all the reason why awareness is so important. That this is an act where significant obligations are cast on the data fiduciaries. Limitations are there in how much data they can collect, for what they can, the reasons for which they can collect it, and how long they can retain it. And this is something that data principals really need to be aware of, alongside their rights to actually exercise it. Because if you continue to behave the way you behaved before the Act came in, then the purpose of the Act is really lost.
So I do want to spend some time on some specific areas. I think we've got a carve-out or a section which talks about children's data. And every law in the world has it. I think this is not something new to India. But perhaps you can explain why there was a need to carve this out, and what is the way in which children's data can be processed, what it can't be processed for, or how you must deal with children's data.
I think the most significant thing in this is, again, because it's a consent-based law, for children, they do not have the capacity, legal capacity, to provide consent. And therefore, in their case, a verifiable parental consent is required. So that, I think, is the primary principle, that a verifiable means of parental consent is ensured without being very onerous, without the process being very onerous. So striking a balance. So that's one key element. The second key element is that you don't want that any data which is collected about a child is used in a way that can harm the child, right? Even with parental consent, you don't use the data in a way that a child's interest could be harmed. You don't target content which is harmful to a child. You have to actually ensure that such content doesn't come towards a child. You don't track a child's behavior online, or you don't track what they're doing in order to sort of send in certain kinds of content which may be harmful. We are aware that there is a fair amount of CSM, child sexual material, which is available online, and if you're not careful, it may go to the wrong hands. And there's also predatory behavior which may sort of affect children. So I think the most critical element there is to protect children from this. And also we are aware that there is certain kinds of content which is addictive, and to protect the children from that kind of addictive content till they are able to figure out for themselves whether the content is addictive or not, or whether they want to do this as a conscious choice, is something which is important. And I think, as you pointed out, this is becoming a concern the world over.
Yeah.
Australia has a law that children below 16 wouldn't have access to social media, which is probably likely to come into effect in December. The UK's Online Safety Act has certain provisions in this direction. So I think everywhere there's concern about how children's behavior on social media, especially in teenage, is becoming an area of a lot of concern.
So if you could, in the way you've done for all the others, if I was a data fiduciary, how would I have to change the way in which I design my site when there's a potential that I could be getting access to children users, or if I'm actually targeting children, targeting in the sense that I'm a manufacturer of toys and I want to sell some toys to children or something like that. And also from a parent's perspective, how do I as a parent now have a responsibility with regard to my child's access to internet or digital things? What does the Act, what tools do they give?
I think right now, we've tried to keep it a little simple, and this is something which will evolve. And what we are being told, and we are trying to make it as technological as possible so that we avoid too much of disruption. And again, even with youth, I think they've gotten used over these past several years for certain kinds of access. In many Indian families, it's probably students and school children and others who are much more savvy with various devices than their parents themselves are. That is the reality we live in. So, allowing for that balance of reality, the basic responsibility of the data fiduciary is to ensure that the person whom they are interacting with is an adult and is capable of giving consent. So one part of it is declaration, and in the declaration, the child has to, or the person has to say that I am a child. In the minute they say that I'm below the age of 18, then there's a need for a verifiable parental consent. So somebody has to come in and say, okay, I'm the parent and this is my child and I permit. So I think many people, and it's important to allow for that kind of recognition, many people will fall into that bracket and will not sort of lie on this. Of course, all of us have done this in terms of, try to pretend to be 18 years old to go and watch a movie which is meant for adults or something. So there will be some who will say that I'm old enough. If they do, then I think we've required, the Act itself requires technological means by which the entity can try and find out. And we understand that there are ways in which they can identify whether the behavior is like that of a child or not. So that is a further responsibility which is cast on the data fiduciaries. Now, once that happens, then of course you can always go back and withdraw and say, look, we now think you're a child, and therefore please go and obtain
verifiable
parental consent. Now, if parental consent in the form that it needs to be given, it's fundamentally on the parent, and there are multiple ways in which this can be done. And it could be based on some database which the data fiduciary already has. If the parent already has an account on a particular social media or something, then based on that you can establish that I'm an adult and this is the way it goes forward. Now, it's very difficult in all cases to figure out that it's actually the parent. I mean, it's like somebody else signing the report card when the child takes it back. So there could be certain instances of that. But I think we have to strike a balance there again between making a law which will sort of, in the process of verifying this, and given the principle of data minimization, in the process of attempting to verify this, you collect a lot more data about the child and the parent than you really need to. So we strike that balance in the Act in terms of there are certain things we take as declarations and certain things which they are required to give. But there's always an obligation cast that the data fiduciary has to have technological means to keep looking at this to make sure that he is dealing with people who have given valid consent.
Yeah, who are either above the age of 18 or if they're below, there is a verifiable parental consent. And I guess parents also need to be aware that they have to exercise this
responsibility carefully. And I guess a lot of this is about awareness. I think many data fiduciaries have big legal teams and others who can actually help them meet all the requirements of the law so that they're not found wanting. But on the data principles side, it's one person against the world. And for them, awareness is very important. And I think one important thing which happened, and in a way we are glad that the process of consultation, because I know that there's been some unhappiness saying the whole process has taken so long, it's a 23 Act, the rules came out in 25. So why did you people take so long? Yeah, I mean, it took a while because there was a fair amount of consultation. But I think in the process of consultation, in the process of actually going out into every part of the country and talking to different groups of people, we've also built the awareness. And I think that is critical. And people knowing about it, media has written about it. There's a fair amount of interest in this particular law compared to many other legislations that have been brought out. And one of the good effects of such consultation has been the greater awareness about it. And we believe that that awareness needs to continue to grow because these are rights which the law gives to data principals, but they need to know that they have the rights and the way that they can exercise them is something.
So I mean, I think we've said a lot about how we must collect a minimal amount of data. But no matter how little data we collect, on the aggregate, it's going to be a lot of data.
That's right.
And one of the fears that we have is data breaches. Data fiduciaries are, as good as their security systems are, susceptible to bad actors, mistakes, accidents, etc. And there's a regime within the Act which talks about what needs to be done for a data breach.
That's right.
If you could speak a little bit about that, because of course we already have regimes for notification under certain and various other things that companies have to follow. But this is different because this is very much about personal data, whereas that is more about the fact that there was a breach. And the personal data affects individuals, affects data principals, affects perhaps their children. So how do we think about that, and what is the mechanism that data fiduciaries will have to comply?
I think the law requires, and this is an important feature, the law requires that the person whose data has been leaked or person whose data has been breached should be intimated as quickly as possible. I mean, we have not actually set a time frame. As soon as the data fiduciary becomes aware that there's been a breach or some data has been leaked, the individual or the data principal whose data has been leaked needs to be informed that there is a possible breach of data and it's possible that your personal data has gone out. Likewise, parallelly, they also have to inform the Data Protection Board and whatever is the reporting based on cybersecurity and other laws. This, we believe, is very, very important because, as you pointed out, it is personal data. And I should know if my personal data has been leaked. In many of these meetings that we had across, many of the experts and others, they said, look, I mean, this is a very onerous requirement. We may not be aware, and it might be a very de minimis issue. The data may not be much. It may be a very small amount of data. And how do we sort of keep track of this? How can we report it? And why should we inform the individual and so on? So I think the only question I ask many of them is that, look, you're also an individual and there's data of yours which is there. At what stage would you like to know? Would you like to know after a lag of 15 days or would you like to know after a lag of 30 days? And I think that sort of stopped that line of questioning completely. I think they turned around and said, no, I think what you say is right and the individual needs to be informed as quickly as possible. The data principal needs to know. I think that's one principle that we are establishing so that whatever protective action you need to take, whatever ways in which you want to sort of protect yourself as an individual, you can. I mean, that is the key element there. And again, it is something which belongs to you. And if it's lost, then, or if it has been given to somebody in an unauthorized fashion, then you deserve to know. That is the principle that is being exercised. And I think that fortunately has come in for wide acceptance now. That the time frame is short, but it's really something which needs to be done and measures need to be put in place to enable that.
And I do want to say that even if your data is breached, doesn't mean that someone is already misusing it.
Exactly.
So the sooner you get the information, the quicker you can change your passwords or whatever else you have to
do
to
protect
yourself.
So which is why the information is important, that you need to get it quickly so that you can take protective action. What is the point of knowing much later? So that, I think, is a principle which everyone has sort of now accepted and decided that it's in line. Thereafter, of course, a more detailed audit of why it happened and all of that needs to be submitted. A more detailed report to be submitted within 72 hours of the first report, and if need be, further reports will need to be given to the Data Protection Board. All of that is there, and there is also a fairly strong penalties mechanism. It's interesting that there are only civil wrongs. There are no criminal penalties under this Act, which again is a very progressive element of what the Act does. But the civil remedies or the penalties which are imposed are fairly large, and it goes all the way to 250 crores in case of serious data breaches. And what is critical and important is that even government agencies are not exempt from this, because government agencies are also data fiduciaries,
yes.
and we hold a large amount of data. And this is something that I always tell the agencies which I meet, that you have a lot of data and you have to treat it with due care. Which again brings us to the other point where I think in India a lot more work needs to be done, which is on cybersecurity. Although we have a number of startups and various businesses which are trying to provide various tools of cybersecurity, when you talk to many of these companies, what they tell you is that the Indian market is not very well developed, because people are reluctant to spend money on cybersecurity because they feel that the consequences of breach in cybersecurity is not so crazy. We've always been a country which is very comfortable using pirated software, not wanting to buy licensed editions and so on. So the cybersecurity risks are also quite significant here, and protecting against such risks, I think, also needs to become a way of life. So indirectly, these penalties under the DPDP Act are forcing people to look at cybersecurity issues much more seriously.
Yeah.
And that hopefully will...
Like for a car, you have to get a third-party insurance. I mean, it's just, if you run a business with data, at the very least, you've got to have cybersecurity in
absolutely
place.
In place. And okay, it adds a few costs, but I think in the long run, it pays off. And it pays off for the economy also.
So one of the provisions that we went through in this long journey of the data protection law was this concept of data localization. Now, happily, that's not there in the final draft. But there is a provision in the law about cross-border data transfers. Every country has got some sort of cross-border data transfer. I look at Europe and they've got this thing called adequacy. And I keep saying adequacy is like data localization. If you're not adequate, you must localize the data. So why we were getting so much flack about it, I didn't understand. But as it happens, our data protection law has a very benign framework. Could you explain what that is for the data
part of the logic is that I think there's a fair amount of data which is available in India and if it is consented and can be used in a number of ways, can be of benefit when analyzed not just in India but elsewhere in the world as well. So I think broadly that is one part of it, that we don't use or analyze our data as much as we need to. We need to build that capacity domestically, but as long as the data gets analyzed, it's not a bad thing. But so that is why we have sort of left that issue open. But as you pointed out, there are some restrictions or some ways in which in certain crucial sectors, the sectoral regulators can restrict. So it has been left to them. Say, if it's financial data or health-related data, there could be some restrictions which are placed in the way that data is treated, especially if you're going to transfer data out of the country. Also, you could, those regulators could also insist that one set of data needs to be maintained in India, which you might need for certain kinds of transactions, which you will need for resilience of, say, the financial system.
So payment data already is there.
Yeah. So those kind of issues, you will need that a copy of the data needs to be maintained in India. So in a sense, locate a set of data here. What you take out is a different issue, but one set needs to be here. You could eventually sort of, for certain tax-related matters and so on, require that data should be located here. So that is something, that window is left open. And that is left to the sectoral case-by-case decisions, which I think is an appropriate framework because it leaves
enough
the
window
balance,
for
enough window for both. And it's more about data residency, that a set of data needs to reside in India, as opposed to you can't take it out at all. So I think that's broadly the framework in which we have looked at this particular aspect. There's also another aspect of trying to protect, and there could be specific cases where transfer could be blocked, and that is intended for very specific things. It is more to protect Indian citizens and their data if it's being sought in some other jurisdiction for purposes which may not be entirely legitimate. So that is a very limited set of and very closely it has to be done on a specific case-by-case basis and not on a generalized basis.
But at this time, there is literally no restriction at all.
There's no
this
restriction.
is a window that's kept open in the future if it's required.
If it's required. That's right.
So there's also some features about this law that don't exist anywhere else in the world. And also that perhaps exist for the first time in our law, in Indian law. The first is this requirement for notice in all 22 official languages of the country, which is, I would have thought that we would do this more often in a country with so many languages, but this is the first time where it's a requirement. What would this mean for data fiduciaries, and why was this introduced?
I think this is important from a context that so much of the business gets done online. Many of the previous laws were possibly written in a context where it's all in written form and somebody will explain it to you and it gets translated into Indian languages and there's printed versions of it you can work with. And there'll be printed forms and so on. A lot of interactions online are not in that form. It's a form that you will see online, or it could be a voice you're interacting with, you'll be on a phone call, some basis like that. And now we have a technological means of actually giving people easy access in their respective languages. And since this is a consent-based law, and the principal needs to really know what they are consenting to, the data principle, I think it's very important that we deal with them in a language that they're most comfortable with or what they would understand. And I think it also reflects that a lot of the digital world is also increasingly going to become voice generated, particularly in the age of AI. And therefore, consent in their respective languages becomes crucial.
There's also this concept of a nominee, which I have studied laws around the world, but that the concept of actually also being able to designate a nominee for your personal data, I've not seen in any other law. And I think it's a remarkable innovation, but it also imposes an obligation on data fiduciaries, which perhaps they're not fully wrap their heads around what it means
the implication could be. I think it's again an important element. You see, what happens is that you leave digital footprints even after you're gone. I mean, I know many people who are unfortunately deceased, but whose digital presence is there, whose either there's a Facebook account or some other social media account or something which is up there and which is not yet gone because nobody knows how to deal with it. And I think if the minute you recognize that the data is something that belongs to the individual, personal data belongs to that particular data principle, then you need to recognize that there is a legacy issue here and which needs to be dealt with in a particular way. It's like money in the bank. It's another asset. So which then means that you have a mechanism by which you have a nominee who can draw the money and then give it to the legal heirs. So likewise here, there's somebody who can deal with all of these issues after you're gone. And there are instances where, if you're incapacitated and so on, some laws don't have it and it can make life very difficult. I knew of a case many years ago when I was in the finance ministry, when a person, a pensioner, government pensioner, fell seriously ill and was in a coma. Money was accumulating in his bank from the government pension and so on. His wife could not access it, and the signature is not available. And how do you sort of deal with a situation of that nature? And when you really need it and you're not able to access it, the person is alive but not able to. So these kind of difficulties are rare, but they're significant.
And it's worth legislating on it.
It's worth legislating on it, and at least to provide for those eventualities. And I think in that sense, the law has been forward-looking in providing for that eventuality.
And then, of course, the biggest innovation I found is the consent manager. We've got a very powerful consent manager framework working in the financial sector, where perhaps global leaders in thinking of this kind of an approach, it's found its place actually in the Data Protection Act, which also is indication of how important it is. So could you explain a little bit about that and how it is relevant?
The consent manager really acts on behalf of the data principal. That is, you have multiple places where you have to provide consent and multiple places where you have to tell them that, this is my data. So you are creating a framework whereby for convenience, you have a consent manager who manages this kind of data for you. The closest comparisons are to the account aggregator framework in the financial world or to what we have attempted with the DigiLocker in terms of, allowing for certain data to be taken for certain limited purposes and certificates and so on. So this is a framework which is, I think people have to think around what the revenue implications of this are, how they will collect revenue in this mechanism, who will pay for the entire establishment. But I find, interestingly enough, companies are already thinking innovatively around this, and they are setting up businesses and practices to support this. So I think it's been a good development, and I'm hoping that we should be able to take it forward.
So we've covered pretty much all the act. There's lots that is there in the details. But I just wanted to spend the last 2-3 minutes in this conversation to perhaps step back a bit and say, we are close to now this becoming a law for, it's already enacted in Parliament, but now to actually apply it to people. And I just wanted you to perhaps spend the last 2-3 minutes talking about how data fiduciaries should use the time that's left now to get ready for what is going to come, and how data principals, how their lives will change after this. And if you could just start with the first, because we've discussed quite a bit during the conversation about how they have to change the way they think, but just some macro thoughts on...
I think the macro thought really is, I think they need to understand that their data is important, their data is significant, and it is an economic resource in somebody else's hand. And you should not part with it lightly. I think that is something that we need to realize. And as a country, we've generally been very compliant and very willing to share. I mean, we are quite happy, and sometimes we even overshare in the social media space, for instance. So I think some understanding of this, and some need to be vigilant and careful on how we actually exercise the rights we have to make sure that you're able to enjoy all the protections that the Act itself offers. And the willingness to actually ask the person asking you for data, saying, why do you want it? What is the purpose for which you want it? And what is the link between the purpose and what you're specifically asking for? Which is to sort of emphasize the data minimization principle. I think they need to ingrain that as behavior, and that behavioral change is going to be crucial. That comes from awareness, that comes from the way that they exercise those rights. As far as the data fiduciaries are concerned, they will have to look at some ways in which they sort of get ready for with technology to meet these requirements. And I think many of them are basically, most of it is digital data, so which means that you are collecting it through technological means. So you have to add on layers to make sure that digitally you have a consent mechanism put in place. You sort of start thinking about why you're collecting the data, and do you need to collect so much, and are you justified in doing this? All of that will become part of what the framework is. And they really need to start thinking about their cybersecurity systems to make sure that they're adequate and they'll protect the data principals' data that they would have collected. They should also start thinking about the kind of contracts they are entering into with data processors, and make sure that, because the legal obligations are all on the data fiduciary. If it's the fault of the data processor, the person who's going to be held accountable is the data fiduciary. So they will have to translate what their obligations under the law are into contractual obligations which they place on their data processors to make sure that they're protected. I think there's a fair amount of work that they will need to do, both in terms of technology systems and in terms of legal arrangements, and for which the government has already indicated that adequate time would be given.
So this is going to be one of the most transformative laws in the country, largely because data is now everywhere. And no matter if you're a manufacturing business or if you are a social media company, you are dealing with data. I think that this law achieves that balance, the balance between dealing with a very complex area with a lot of simplicity. And I'm looking forward to seeing how this actually unfolds as the law comes to pass. Mr. Krishnan, thank you very much for taking us through all of this. It's a lot that we've covered in a short period of time, but I hope that this provides the listeners clarity and a path through what is coming ahead.
Thank you very much. And I think it's an important legislation which affects all of us, and all of us have rights which we can exercise under this. And hopefully this should reach a lot more people and they learn more about this. Thank you.